Red and blue lights fill your mirror. You pull over, hands on the wheel. The officer leans in and asks one question, not license and registration, not the reason for the stop, just, do you know why I stopped you? That question has a documented courtroom track record, and it is not in your favor. After digging through body camera research, training manuals, and Supreme Court rulings, I found the exact sentence that shuts this question down cold and the specific legal reason every other answer, including "I don't know," hands the officer, something he did not have 30 seconds earlier. The fishing question. Here's what almost nobody realizes. "Do you know why I stopped you?" is not curiosity. It functions as a diagnostic prompt in training circles, an open-ended admission tool built to do one of three things: get you to confess to the violation before the officer has to prove a thing, get you to volunteer a completely different crime he never even saw, or retroactively patch a stop that was legally shaky from the very first second. A Stanford analysis of nearly 600 body camera recordings found that stops where officers skip stating the reason and instead go fishing for the driver's guess are dramatically more likely to end in a search, handcuffs, or an arrest. Picture the exchange. Officer says, "You know why I stopped you tonight?" Driver answers, "I think maybe I was going a little fast." Officer replies, "That's exactly right, license and registration, please." And now that guess sits permanently inside the citation narrative. The officer already watched you commit the violation with his own eyes. He does not need your guess to prove it. What he needs is your words on his body camera, because your words, unlike his own observation, can be picked apart, quoted, and used against you later without a single objection from your own attorney. Every "I think I was speeding" or "was it my tail light" is not politeness. It is a recorded, time-stamped admission sitting on a government server, waiting for any prosecutor who wants it. Training materials used in departments across the country describe this exact opening as a rapport-building question, but defense attorneys who review hundreds of these stops describe it far more bluntly as a confession invitation dressed up in a friendly tone. The Miranda gap. Most drivers believe police must read them their rights before any questioning begins. That belief is wrong at the roadside, and this exact gap is what the opening question is engineered to exploit. In Berkemer versus McCarty, a trooper watched a driver weaving between highway lanes, pulled him over, and asked whether he had been drinking, all without ever mentioning Miranda. The Supreme Court ruled that a routine traffic stop is not custody for Miranda purposes, even though you are clearly not free to just drive away. No custody, combined with no formal interrogation warning, means the officer can ask you almost anything roadside, and anything you say back is fair game in court, all without ever reading you a single right out loud. That is the loophole, hiding in plain sight. The officer is legally permitted to interrogate you in every practical sense, while the law still pretends this is simply a friendly conversation between two people. The moment you answer that opening question in any form, guess, denial, or nervous explanation, you have stepped directly into a legal gray zone with zero warnings and zero built-in protection. And the only thing standing between you and that gap is the exact sentence you choose to say back to him. McCarty himself learned this the hard way. He answered the roadside question, made an admission, and later made another admission at the station, and both statements were ultimately allowed into evidence because the court found neither moment counted as custodial interrogation. The one sentence. Here it is in full. "Officer, I am invoking my Fifth Amendment right to remain silent, and I will not answer that question or any others." Say it once calmly and then stop talking completely. Now let's break down exactly what each piece of that sentence is doing. Officer keeps the tone respectful from the very first word, and that matters because it is being captured on camera the entire time. "I am invoking" is an active present tense legal act, not passive silence, because courts have made clear you must affirmatively claim this protection before it legally applies to you. My Fifth Amendment right to remain silent names the exact constitutional protection by number, removing any ambiguity about whether you were simply being shy, rude, or evasive. I will not answer that question refuses the specific trap in front of you without confirming, denying, or guessing at the underlying violation. Or any others is the piece almost nobody thinks to add, and it is the piece that matters most, because it extends your invocation forward in time, closing the door on the entire chain of follow-up questions before the officer even has a chance to ask them. Why guessing costs you? Saying, "I don't know, officer," feels safer than guessing. It is not nearly as safe as people assume. Courts have repeatedly treated uncertain, hedging answers as voluntary statements rather than protected silence because you still spoke. You just spoke vaguely, and vague statements still get transcribed, still get quoted inside a police report, and still get used to argue that you were engaged and cooperative, rather than legally invoking anything at all. Even softer phrases like "I'd rather not say" can fall into this same trap because they never name the specific right being claimed. And an officer's report can later frame that softness as simple reluctance instead of a constitutional invocation. Meanwhile, guessing correctly, "Was it my brake light?" hands the officer a spontaneous admission he can cite without lifting a finger. And if you happen to guess wrong instead, the officer now has an inconsistent statement to compare against whatever he later cites as the real reason for the stop. An inconsistency is exactly what gets used in a report to argue you were nervous, evasive, or hiding something bigger than a traffic violation. In many states, a single admitted drink is enough on its own to justify a field sobriety request, and a resulting conviction can carry heavy fines, a license suspension, and even a short jail stay on a first offense, consequences that trace back to one voluntary sentence spoken at the window. Stay calm here, because panic is what produces both the guess and the hedge in the first place. Breaking the chain. This question is rarely asked alone. It functions as link one in a documented sequence. Forces warning. Officers are trained to move from that opening question into "Where are you coming from?" Then, "Have you had anything to drink tonight?" Each one designed to build reasonable suspicion out of your own sentences rather than the officer's independent observation. Answer link 1, and you have already handed the officer momentum to justify asking link 2, then link 3. The one sentence breaks this chain at its very first link, not its third or fourth, and if breakdowns like this are giving you legal footing you did not have 5 minutes ago, subscribe right now so the next constitutional gap gets closed before you ever need it. Because once you have clearly invoked, any continued questioning that follows carries far less weight if it is later challenged in a suppression hearing, and experienced officers know this. That is why an officer pushing past a clean, clearly stated invocation is itself often flagged in these hearings as prolonging a detention without new, independent justification, and prolonging a stop past its original purpose is its own separate constitutional problem stacking directly on top of the first one. So you're now protected on two separate fronts with one single sentence. 2 stops, 2 endings. Picture 2 hypothetical drivers, same violation, same road, completely different sentence. Driver 1 hears, "Do you know why I stopped you?" and answers, "I guess I was going a little fast." The officer replies, "A little fast, huh? How much have you had to drink tonight?" And now the driver, rattled, adds, "Just 1 beer earlier." One admission just became a second admission, and the citation folder is growing by the sentence. Driver 2 hears that exact same question and responds instead, "Officer, I am invoking my Fifth Amendment right to remain silent, and I will not answer that question or any others." The officer pauses for a beat, then says, "All right, license and registration." There is no follow-up question to attach to anything because there was nothing offered to attach it to in the first place. Same flashing lights, same stretch of road, 2 completely different case files sitting in 2 completely different folders by the end of that night, and only one of those drivers is walking away with a clean record of the encounter. Prosecutors do not need much to build momentum. 1 voluntary sentence plus 1 nervous follow-up is often enough to justify a field sobriety test that never would have been requested otherwise. After you say it. Once you deliver this sentence, the officer's remaining options narrow fast. He can still write the citation he already had solid evidence for, and he can still request your documents, but he loses the conversational runway he was counting on to build anything beyond that original violation. Some officers will test you anyway, repeating the question in a softer tone or adding something like, "I'm not trying to get you in trouble. Just answer me here." Stay calm, stay polite, and repeat the identical sentence, word for word, without adding new commentary or explanation. Explaining why you're invoking quietly undoes the invocation itself, so resist that urge completely. If he goes further and orders you to answer anyway, ask calmly, "Officer, are you asking me or ordering me to answer?" A request you can simply decline. An order gets met with, "I am complying under protest, and I am still not answering questions." If he then claims your invocation itself seems suspicious, resist the urge to defend yourself with an explanation, since silence paired with a calm demeanor is what the sentence is designed to protect, and adding commentary on top of it only reopens the door you just closed. Say it right. Tone carries just as much legal weight as the words themselves. Stay calm, stay polite, but stay firm throughout, because courts and body cameras both register attitude, and a smug or combative delivery can undercut an otherwise legally sound sentence every single time. Keep your hands visible on the wheel, your voice level and even, and remember that your own recording and the officer's body camera are both capturing every syllable of this exchange, so let that footage show a calm, deliberate citizen, not a nervous one, stumbling into an accidental guess. If a second officer walks up and repeats the exact question, hoping for a different, looser answer, give him the identical sentence right back. Consistency across every officer present is what makes an invocation legally durable in a courtroom instead of a one-time fluke that a judge can wave away. Before you drive again. The entire lesson here comes down to one idea. This question is a trap dressed up as small talk, and only one sentence refuses to step into it. Lock in your 4 essential phrases for every stop going forward. Am I free to leave? I invoke my right to remain silent. I want an attorney. I do not consent to any searches. State law shifts some of the fine print here. California's Assembly Bill 2773 now requires officers there to state the actual reason for a stop before questioning you at all, with a suppression motion available as the remedy if they skip that step entirely. Texas, Ohio, and Indiana carry no equivalent statute on the books, leaving this exact question fully legal in those states. Verify your own state's current rule before you rely on any of this. Print this sentence tonight. Say it out loud until it feels automatic. Because a stumbled invocation under pressure is barely better than none at all. Say it to a passenger. Say it in the mirror. Say it enough times tonight that pressure cannot shake it loose later. This is educational content based on case law research, not legal advice for your specific situation. So talk to a licensed attorney in your state about how this applies to you. If this helped you understand your rights, tap like, subscribe, so this kind of case law breakdown keeps landing in front of you. Hit that bell and share it with someone who drives. For the complete constitutional picture, the next video breaks down a related protection most drivers still invoke incorrectly, and it's sitting right here on screen. Tell me in the comments where you're watching from and what time it is right now. If this changed how you'll handle that question next time, hype this video so it reaches somebody before their own next stop. You already know the sentence now. Say it like you mean it and let the silence handle the rest.